Good afternoon. Welcome back. My name is Marlena Pinto, and I'm the editor-in-chief of the Colorado Technology Law Journal. We're a student-run technology, law, and policy journal that publishes scholarly articles on topics like telecommunications and space law, privacy, entrepreneurialism, and most relevant to why we're here today, AI and intellectual property. We're fortunate enough to have Silicon Flatirons host these conferences, sparking thoughtful discussions that can ultimately turn into articles for our journal. In fact, our spring 2024 issue will include articles covering views from the investment crowdfunding symposium that happened last month. So keep us in mind as you're thinking of these topics, and if you are so inclined to write something yourself, please consider submitting it to our journal for publication. With that said, I'm happy to get back to today's program and introduce the next session, which will discuss the future of generative AI and copyright policy. So I'll pass the mic to our moderator for this session, Professor Blake Reid.
Thanks so much. All right, let's get started. And I think we're going to pick up in just a second with Professor Braca's provocation from the last panel about copyright serving as an incredible misfit for the range of policy issues. I think there's a lot to unpack with what Professor Braca teed up. But before we do that, I want to introduce our panel, and I want to do this in a way that doesn't go through people's bios, but rather gives folks a chance to introduce their view on this discussion. And the question I want to ask everybody to grapple with for like no more than a minute is, how do you construct generative AI? Or how do you see generative AI from your professional perch? And this morning, through the lens of copyright law, we constructed AI in a few ways. We constructed it through the lens of authorship. Is AI an author or not an author? Through the lens of infringement and fair use, we asked, is AI a copy machine or a legitimate copy machine or not? But there are lots of other ways that we might construct AI. We might construct it as a consumer product for search. We might construct it as a tool for creators to aid in their work. We might construct it as a replacement for creators. We might construct it as an object of research and development. And I'm sure you all will come up with some other ways. But I'd love you to reflect what brings you to this conversation. How do you think about generative AI? And I want to start with Sarah Jeong, the Deputy Features Editor at The Verge. Sarah.
Well, in my day-to-day work, we see it as a thing to cover, right? And that means something that is misinterpreted, lumped in really a lot of different things that operate very differently. Things that are not even necessarily AI, by even an expansive definition of AI, are lumped in together. And as part of our work, we try to be very careful and we try to interrogate what the technology is that we're looking at. But yeah, I think that the thing that I'm primarily interested in is that it is a source of content. Notice I didn't say like a content creator. I think that there's been a really interesting linguistic shift, like in the last even 10 years. At first, we started talking about the creative industry as the content creators, the content industry, and then eventually we shifted to talking about creative work as content. So people start referring to their art as, oh, I make content, which I think is really fascinating because you're basically admitting that your artistic output is ultimately ad inventory. And I think that generative AI is really interesting because it is creating a thing, not necessarily art, not necessarily culture, not necessarily information, it's creating content. And but that's what's relevant right now, is ad inventory.
Perfect. All right, I'm going to shift us up to the screen to introduce another speaker who's, despite being on the screen, is not an artificial intelligence, although it possesses the power of one. And that is Amanda Levendowski, who is an associate professor of law at Georgetown Law. Amanda.
I think that generative AI is a great source of billable hours for a number of lawyers. As a clinical professor myself, it's definitely a source of opportunities for my students to learn about where socio-technical harms, law, and technology intersect. But I would also just say that to go off Sarah's really astute point that it generates content, a lot of that content is bullshit. And it's really good at generating beautiful bullshit. And I think that's something that we have to hold in our minds at once, which sometimes it's really compelling and interesting and engaging. And yet a lot of what it's really doing is reflecting and amplifying human biases back at us. And keeping both of those things in mind, I think is really key to the conversation.
Thanks so much. Moving down the row, we have Ellen Goodman, who is a distinguished professor at Rutgers Law School, but also wears some other hats that I'll let you explain to whatever extent you want. Ellen.
Oh, right, let me just dispose of that. So I wear another hat where I'm on loan to NTIA, the Department of Commerce, working on AI accountability policy. And the only other thing I'll say about that before I tell you that everything I say is in my personal academic capacity is that Colorado lent us two amazing interns, one from the law school and one from the Department of Computer Science, Khalef Botan, and then they're sitting here, and Christine Chang. Can you raise your hands? Like without their, I mean, it is absolutely true that students from here get amazing opportunities, and it is absolutely true that they have been and are amazing assets to the work we're doing. Okay, that's it for NTIA. So, you know, and I think the interesting thing is, and we'll talk about copyright and the hammer analogy, and I think probably we all look at generative AI and AI in general, depending on what tool sets we're bringing to it. And so I come from a media policy background, and my first interest, my first contact with algorithmic decision systems and with AI was really about democratic self-governance and human autonomy, and the question of whether these tools empower people to take more control and exercise more authority in their lives, or whether they do the opposite by obscuring decision-making, producing bullshit, and otherwise disempowering people. And so it's that fulcrum that I'm most interested in.
Awesome. All right, moving down the line to our colleague from across campus, Casey Fiesler, who is an associate professor of information science here at CU. Casey.
Yes. So for me, generative AI has been a source of TikTok views. One way that I've been thinking about it is how is this tension between like in what kinds of tasks is it going to be doing to replace us versus augmenting us, and I think the answer is both in different contexts where any kind of replacement is probably going to be bad, but in the end, when people say like, oh, AI is stealing our jobs, AI isn't doing anything, people are firing you. So that's not really a feature of AI, but more of a consequence. But I was trying to think of like a way that I would use AI this kind of AI that I would consider kind of appropriate in terms of thinking about what it could do for me. And I would not want to use AI to help me build a world for a Dungeons and Dragons campaign, because I can do that for myself. Like that's the creative thing that I would be really excited about doing. But what I would love to do is write 100 words about an NPC that I want to build and then have ChatGPT give me a character sheet for it, because that seems like not fun to do and like a lot of work. And so, but then I would take it, and if I didn't like it, I would change it, right? So I think that there are ways that it can be like a helper in the most generous way there.
Fantastic. All right. Last but not least, over to Mike Fricklas, who is the Chief Legal Officer and Corporate Secretary for Advanced Media. Mike.
Thanks. Just to kind of get a little context, Advance is a company that's in a bunch of different things, from venture capital to owning media companies. We own the Condé Nast magazines. We own a bunch of newspapers around the country, and our roots are really in journalism. And so even though the journalism from an economic point of view is a relatively small part of the overall enterprise, it's one that I'm really interested in. And before I was at Advance, I was general counsel of a company called Viacom, which was in media in many, many different ways. We were in books, we owned Paramount Pictures, lots of cable television, lots of things like that. My whole career, I started here as an engineer from the University of Colorado. My whole career has kind of been at the intersection of business and technology, and there have been lots and lots of transformations. There's two kinds of transformations from technology. One is the good stuff, and that could be some things become obsolete because you're able to do them better, and you lose some jobs because the people who are doing the old stuff don't have a thing to do anymore. Maybe you were the person who made brass belt buckles in 1810 and fashion changed, and there's no brass belt buckle industry anymore. And so your jobs are being destroyed. But there are also those things that are being damaged in the way that are really necessary things. And so in my case, the thing that I'm spending more of my time on is thinking about journalism, because the AIs ingest a lot of our work, and that's news reporting, but it's also creative work. Think of the New Yorker, Vogue, Vanity Fair. Think of the newspaper work, and providing people with an alternative way to access the same information, but without putting the effort in to create that stuff. And it's not stuff that AI creates. So you need those things. AI can spit back to you the story that was written about the Ukraine yesterday, but it doesn't go to the Ukraine and walk among the bombs and try to figure out the personal injury stories that are going on there. And so we need it. There's also work that's being done I'm getting ahead of myself. Just this particular one, that's how I'm spending my time. Somebody made the comment, it's keeping a lot of our lawyers busy because we have a business to run, and we have to figure out not just like what we think the theory should be about an alternative to the copyright system, but how we're going to make our business run and the journalism work over the next 3 months, 6 months, 2 years, in addition, and try to figure out how to work these systems into making that happen.
So I want to reflect some of these back just so we get a sense of the breadth here. So I heard AI as a source of content. I heard AI as a source of socio-technical harms, a source of bullshit, a source of big effects on democratic self-governments, a potential threat to human autonomy, a potential cause of disempowerment, a replacement for us, or a replacement for people to replace other people, maybe an augment for us, maybe a destructor, displacer of labor, maybe as a consumer of other content, and maybe as an output and an imperfect replacement for journalists. So this is a pretty wide range of social impacts that we're dealing with here. And as Professor Braga teed up in the previous panel, we are filtering this all through copyright and filtering it through pretty arcane doctrinal questions about authorship and about infringement and fair use and so forth. So I want to go meta for our kind of first question here. And I want to turn to Sarah, because your work has explored historically how copyright has showed up first on the scene, right? This is not the first time that a technological disruption has come along and copyright has been there to meet it, and with lots of consequences, good and bad. So I wonder if I could turn to you to break down how has copyright succeeded and failed in this endeavor in the past, and then we'll turn to AI.
Yeah, so I mean, I'm not going to go all the way back to the printing press because I don't remember when that happened. I was probably too young. But you brought up this question yesterday, and it was primarily to a room full of 1Ls, and so I had to explain what Napster was. But I don't think I have to explain Napster to you guys. What happened with the internet is, like, in the 90s, there was like a genuine question of whether the law applied to the internet. And like, it seems really absurd for us to think about it now, but there were actual books written by well-regarded people, Jack Goldsmith, Tim Wu, one of my favorite books, called Who Controls the Internet, where they had to explicitly make the argument that the government in fact controls the internet in specific ways. And they had to actually approach that question in a serious way. And what happened was that in the 90s, the first to rush into sort of the breach into this wild frontier, it was copyright law. Seems really weird now. It's like the fact that copyright got there before national security, before privacy, kind of before child exploitation, not really, but also kind of. It got there first, and it was the most successful in bringing the internet to heel. To the point where when startups were spinning up very early on and sort of flying by the seat of their pants, and they didn't have a lawyer, they'd go like, no, you really need a lawyer. It's like, for what? It's like, oh, you need a DMCA agent, you need a copyright lawyer. Obviously these days, they're aware, I hope, that they need many more different kinds of lawyers. But yeah, like copyright, for whatever reason, became the first thing. And so what you see is immediately, whenever you have a problem on the internet, people run to copyright to try and fix it. So you see, there was a case in 2014, super fascinating one, Garcia v. Google, where a woman who had sort of been tricked into playing a part in The Innocence of Muslims, that's the film that may or may not have sparked Benghazi, she was receiving a lot of death threats on the internet because of this upload to YouTube. And so she sues Google for, based on her copyright interest in this film because she appeared in it, which is not how copyright works. Just because you appear in a film or in a photograph doesn't mean that you own that work or have an interest in it whatsoever. And so it goes through, it's a really convoluted case, and it's like really interesting to go and look at the sort of Ninth Circuit argument there, or the second one, the en banc one, because the lawyer for Cindy Garcia starts out by reading out the death threats. And immediately the judge interrupts and goes, what does this have to do with copyright law? And yeah, like the audience was full of like, it was MPA lawyers, it was like Hollywood lawyers, like they were here because they were really invested in how this was going to go down for copyright law. And meanwhile, Cindy Garcia just wanted to stop being afraid. And so you see this pattern play out again and again where people run to copyright to try and get things done because there is a robust structure in place for taking content down from the internet, for judging whether or not content should stay up on the internet, and also for sort of, reaching through the screen and finding the person who did the thing and like getting them. Because the RIAA was incredibly successful in, subpoenaing IP addresses, finding individual infringers, going after them, basically finding who did this anonymous person who did this, and getting them. And that's copyright is an incredible ill fit for when you're like dealing with, privacy concerns, being stalked, being threatened, domestic violence. And yet it comes again and again to the fore. I think that the law has become a little more robust in dealing with a lot of these other issues over time. The internet is certainly much more regulated than it was when I was in law school, which is not that long ago, honestly. But still, it is maybe copyright on the internet is still probably one of the most robust bodies of internet law that we have.
So I want to open this up to the panel, and I think the lifespan of the commercial internet is probably the perfect sort of technological period to cabin our inquiry to here. We're 25 years into the life of the commercial internet. We're sort of at the midlife of the internet, call it. How, as we take measure of that, has copyright stacked up in being that first law of the internet? We've got some examples of it not doing so well. Other perspectives?
I want to challenge this framing that copyright's first contact with the internet, because in some ways, the reason why we think of it that way is because there was a recession, and 230 was actually kind of first contact or non-contact, right? And so 230 precedes all of that and says we're not going to make any laws around here. And I think that as a result, when I look back on those 25 years, it's been, was it 25 you said? Was it?
Yeah, right. If we go back to 96,
Yeah.
then we're even more than that.
Yeah. That it's kind of, you know, the way pine trees, you know, create a dead space underneath them, this kind of monoculture. And like copyright kind of has operated that the lack of any laws. And so we don't have this kind of tort muscle around that we might ordinarily have around the internet. And I think we're paying the price for that in AI because copyright is the only kind of muscle that's been exercised.
So maybe it's a little different in that copyright at the introduction of or the inception of the commercial internet was coupled by an intentional abdication of every other corner of law.
Yes.
Great. Other thoughts, Casey?
Well, I think this is so interesting, and I think that one of the reasons that we got to this place where copyright has this kind of power, especially in online spaces, is because of the systems of power that underlie it. And like, you know, if you're talking about something like YouTube's content ID, like what is YouTube gonna do to make Universal Music happy? But now that everyone is a content creator, there are ways in which copyright law becomes the only kind of recourse for like normal people. We see this for things like revenge porn, but also like very recently a content creator, a friend of mine who's extremely popular on TikTok and Instagram, did not have a Facebook page because like, why would she want to be on Facebook? And someone was taking all of her videos and reposting them on a Facebook page that had 100,000 followers. And they all thought that this page was her. And she like messaged the person running it and they were like, well, I'll hand it over to you if you want it. I'll be your social media manager. And she tried for a long time to get Facebook to take down this page because it was impersonating her. And finally I said, file a DMCA notice. Gone. Hours later, because that's the only thing that often works. So now we're thinking about the copyright issues underlying generative AI. You know, people's content from the internet, for example, being used. I still think we're seeing an interesting power dynamic here because the lawsuits that we're seeing that are getting attention are things like Getty Images and famous authors and that sort of thing, and not like, you know, indie artists on DeviantArt or whatever.
All right, I promise we'll get to AI, but we'll get into reactions, and then Amanda, if you want to jump in on this one, or if not, we'll jump to the next question.
I do think that one of the things that's really interesting when the internet first, you know, became a thing, there was a lot of writing about read-write culture and the like, you know, about everybody becoming a creator and it not being concentrated among a few companies who had the power to exploit copyright. And I think that a lot of those early cases had to deal with those big companies. But I think one of the things I've really seen recently is this whole point that you're just raising, which is now that everybody's a creator, they're also starting to see the threat. Neil deGrasse Tyson was on Stephen Colbert's Late Show on Monday night, and he was asked this question, and he said, I feel really strange about it. You know, AI is a really great new tool. It has all this capability, but I'm really uncomfortable with the idea that my book was taken and is being used for this new product. And so I think one of the things that's changed is that, well, and this point that you raised, like we put up videos, we see other people take our videos, download them and re-upload them to YouTube and generate thousands, hundreds of thousands of views for themselves. We've seen, you know, we see lawyers getting copies of articles. People are complaining about the articles, and the articles weren't generated by us. You know, they were faked. And so kind of bringing some law and order to this whole universe, I think is something that involves everybody and not just the large companies.
Amanda, any thoughts on this one, or should we move to our next topic? I thought AI was going to solve our mute problem. Not happened yet.
I hope so.
It's still a work in progress, which is exactly what I think this panel is about, is the fact that there's still a lot of bugs in the system. And I want to go back to what Sarah was saying about copyright being one of the first on the scene. That's because the internet is really made out of copies. And so when you're looking for a law that relates to copies, even though Section 230 is also there kind of looming as well, if you're dealing with copies, it makes a lot of sense. And then you have these two competing parties thinking about fairness. You have people who want to use copies thinking, well, it's fair for me to use this copy so that I can expand knowledge or share music or create art or do whatever they want. And then there's other people that say, hey, this is really unfair to me because I want to be getting credit, compensation, and consent to use my works. And that's the kind of tension we've been seeing between these two sides for as long as we've been talking about copies on the internet. And I think that that reveals a real FU in fair use from the perspective of authors and artists who want to have another C word, control, over how those works are used. And that comes into tension with the whole doctrine that governs fairness in copyright, because fair use allows for uses without any of those things authors and artists want. No consent, no compensation, no credit, all totally fine in the right circumstances under fair use. And so it makes a lot of sense that now that we're seeing another conversation involving really a debate about what's fair on the internet, copyright is there as it always has been.
Well, Amanda, why don't we take this opportunity and shift into AI? And we've got this sort of backdrop of the internet, maybe contestable how copyright has played its role. But let's shift into thinking about copyright as a tool for governing and regulating AI. So you've been a proponent, at least in some of your scholarship, of analyzing AI problems through the lens of copyright law. Take us down what the pros and maybe if you feel like it's some of the cons of using copyright as a lens for AI regulation and governance. What does that look like?
Yeah, so I think one of the cons is that copyright law is supposed to promote a very particular type of progress of the useful arts and sciences. It's not to promote social justice. It's not to promote equity. It's not to promote fairness in the colloquial sense, not in the socio-technical sense. And sometimes it happens to do those things. We can look at some of the Supreme Court cases over the years, some of the circuit court cases over the years, some of the district court cases over the years, and see where those values happen to align. But that isn't really copyright's purpose necessarily. And so in my scholarship, I've talked about how fair use may be necessary to mitigate some of the biases we're seeing in AI systems, particularly around race, gender, sexuality, class, and disability. But at the same time, that doesn't mean that it's promoting fairness for the authors and artists who would really prefer that their works not be used to debug those systems for whatever reason. And so in the other context, on the other side of things, we have very specific uses that may not be fair use. Like I think certain types of face surveillance that are using profile pictures for the exact same purpose of recognizing faces, which I call particularized identification. But that's cutting it incredibly fine to make a distinction between these various types of AI uses of copyrighted works. And so I think the challenge that we're really seeing now is, like I was saying, this FU and fair use, this lack of agreement about what actually is fair from a fair use perspective. And I think that's what a lot of this litigation is going to get at as we see it unravel. Or ravel. I don't know if it's going to ravel or unravel.
So I want to open it up to the panel on I heard at least two fronts, and maybe let's start with this notion of interest convergence between copyright's interests and broader questions of whether we think about social justice or think back to the previous panel about goals of the market and how those might diverge sometimes. Curious for folks' reactions on that.
Yeah, actually, so previous applications of copyright to things that aren't really quite copyright, I've been pretty critical of. In this instance, I actually think this is kind of in copyright's wheelhouse. The downside, as Oren stated in the next panel, is that copyright in the United States, at least, is very much market-oriented. And the harms, the most urgent harms that are posed by generative AI, which, by the way, I don't think it's 100% bad, but there are some serious problems sort of looming. They're not really market problems. Because here's the thought experiment. It's that let's pretend we lived under full communism, fully socialist society. No one has to worry about going hungry tomorrow. All of the artists have health care. They live in stable housing. They don't have to worry about getting sick or taking care of their children or sending their children to school, right? Do we still have a problem here? And it's yes, actually we do, because there is more going on here than compensation, than the sort of systems at play for paying for work. It's that when you make it so cheap to generate content, and again, I'm not saying art, I'm not saying culture, I'm not saying information, because none of this stuff is necessarily informative, true, valuable, or even contributing to human flourishing in any way whatsoever. When you have so much of it, it becomes harder to find the information you're looking for. And this is already a thing we're seeing with search engines. We're seeing search engines decay in their reliability over time. Because, I mean, if you just sort of look, first page of Google results, a lot of that's already AI generated, a lot of those links. A lot of those links are not necessarily reliable information. You might notice that it's a lot of really wordy, repetitive paragraphs, right? Like and that it's not necessarily true. It's not necessarily even addressing the question that you asked. It is becoming harder and harder to find the answers to the questions that we have. It's harder for us to figure out where supposed answers came from, who said things, whether it was actually said by the person. And then we're just getting, there's also sort of much harder to measure this impact, but like when you get sort of the culture flooded with stuff that's just rehashed images that are just mixed up in between pieces of everything that's existed before over and over again, what does that do to us? Like as people, as a culture that wants to progress? I don't know. I actually really don't know, but I don't love it. I know as journalists, there is a problem when consumers cannot actually find out what's happening or cannot trust what it is that they're reading, and there's no reliable way to distribute and disseminate information because there's too much information. Historically, the problem has been that there's not enough access to information, that there's not enough information, that we aren't incentivizing the creation of information or making it accessible to people at like a price or for free in a way that like is good for society. But right now the problem is now and increasingly going to be that there's too much content and that it's not possible to navigate through all the content. So under full communism, it's still a problem. And so yes, there is an issue there with copyright being market-based. It's maybe not a good fit. On the other hand, copyright has been, since even before the Statute of Anne, the primary way in which the state has regulated the dissemination of information for the purposes of strengthening our culture, strengthening our bonds with each other through how we communicate, right? So why not? We have this robust body of law. Why not turn it to the purpose of this big problem? Other part is that we have the robust body of law, but the institutions already exist. We already have scholars. Imagine if we went at this from a privacy perspective, which there's a lot of privacy problems, right? There really are a lot of bias problems. I'm glad that someone is working on this stuff, but it's if we went primarily to that first and foremost and leaned heavily on it, we'd find out really fast that the US has very much underinvested in regulating anything from these perspectives. And that's a problem for sure, but in the immediate right now, what framework do we turn to? I don't think copyright's such a terrible fit, honestly.
Mike, head down.
Yeah, I think those are a lot of really interesting and important problems. But I think one of the ways that we think about some of the solutions to some of those problems is that the reputation of the speaker is tremendously important, and maintaining that connection with the truthful understanding about who's speaking and relying on sources that you know to be trusted. So one way you do that's through brands. The New York Times has a great brand. And if you go to the New York Times, hopefully you have the experience that whether you agree or not with their opinions, you trust the facts that are generated, and you know that they're thoughtful. The same thing with a professor at the University of Colorado. They have a name, they have you're going to get a certain amount of useful information. I think we do rely
a lot of useful information.
I think we rely a lot in navigating this expansive amount of information more and more on finding somebody, finding a source, finding sources that deliver you on a consistent basis the kinds of information that you want to achieve. And so staying away, thinking more about the policy front than the copyright front, I think sets of rules that allow people to have trusted connections with sources of information is a very important aspect of the ecosystem.
Mike, can I follow up, just a really quick follow-up directed at you, and then open it up to the rest of the panel to keep going on this convergence question. Do you feel like copyright accomplishes that goal, or in what ways does copyright succeed on that front, and in what ways does it fail?
Fair enough. It succeeds in some ways and fails in others. So in terms of success, what it does is it provides, and I'll use the New York Times again as my example, it provides the New York Times with a source of revenue. The people who like the New York Times, they read the New York Times, they trust it, they appreciate what it does, they engage with it in an economic matter. So they pay for subscriptions, they see advertising, the New York Times gets traffic that's helpful to their advertisers. And so there's that market kind of transaction where copyright enables the journalism, it enables the brand, it enables the trusted source to continue to do the very hard work through hundreds and thousands of journalists to give people something that they want. And so if copyright is functioning correctly, and there's lots of issues around the edge, if it's functioning correctly, that works. I think copyright, the bill, I won't go back to the statute of Anne, but we're pretty much operating under a law that was mostly written in 1909, or in the years leading up to 1909, with some tweaks in 1976. And fair use is a judge-made concept that's really a policy set of rules more than it is a legal set of rules. You can have cases that go absolutely opposite directions depending on the situation. And that's true for other kinds of concepts built into copyright, like what is a copy, to what is a derivative work. These are words that are not really that filled with meaning, and they leave a lot of discretion. And so if you're a journalist trying to figure out how to make a living, and you're trying to say, okay, what can people do with my work that's going to compensate me or not compensate me for the effort that I did, it's really hard to have a level of predictability. And as well, I think really big and well-funded actors have pushed some of those concepts beyond any recognition. Those concepts weren't written, to start out, they weren't written for technology. They were written for normal expressive kinds of works. Does this play look too much like that play? Did they just change the name of the characters? Those are the kinds of issues we were dealing with in the first place, not whether generating billions of page views in a particular aspect undermines the incentive to create or not. They're just not designed. So all that's judge created. Judges, they have two litigants in front of them. They don't have all of society. They don't have hearings. They don't have, major policy debates. And I think, our Congress has been, very in a situation that makes it very difficult for them to get into constructive policy debates as well. So it's really strained what copyright can do, and it's left to just a high degree of unpredictability.
So I want to get into institutions down the line, but before we leave these questions about copyright doctrine and convergence, I want to make sure to invite Casey and Alan in on those. Any reactions on that?
I actually think that your point about the importance of the source of information is going to be really, really important. And I've been thinking a little bit about how mechanisms for attribution could potentially help with that. Like when you see a screenshot of a tweet from the CDC, if there was some way in a technical manner that you knew for certain that came from them. But even then, I feel like there's this very generous assumption that people care. And one of the most pressing things I saw recently was that someone photoshopped a tweet from the CDC and then tweeted, oh, the CDC tweeted this and then deleted it right away, but I got a screenshot and it was about there being an Ebola outbreak at Burning Man. And this is what started.
That's not funny. Sorry, go ahead.
But so many people believe, 100% believed this just because they saw a screenshot of a tweet. And everyone knows how easy that would be to fake, I would like to think. And now the issue is that you're going to see a press conference with the director of a CDC, a video of it, and you're not going to be able to know that that's real. And so the only thing that you can do is trust the source of the information. Did it come from a professor at CU Boulder, or did it come from some random TikTok user with like a cartoon avatar? And so how do we get people to care about the difference? I don't know. So
Well, Casey, I want to ask you the same follow-up I asked Mike, which is, does copyright give us any tools at all to effectively solve that problem?
see, I think actually this is one of the examples of where it doesn't. I mean, I think that the kinds of things that have been brought up, privacy, bias, misinformation, I don't know that copyright does give us the tools to deal with those things. And you're absolutely right. Like we don't have, like, we're going to end up with these AI laws that are like mishmashes of all of these kinds of things that then only apply to AI, which I think is going to create a weird regulatory framework. Like, you know, we watched like congressional hearings with all of these complaints about where our data on social media is going, and yet we have like almost no meaningful federal data privacy laws. And we might get something related to AI, and then it won't help us with everything else, which is a slightly different issue.
All right, I think we're going there, so let's go there. Let's talk about the.
I want to.
Yeah, please.
Okay, so just take a step backwards. It's not surprising that copyright is being used to deal with fears about job displacement, human dignity, and autonomy, concentration of power. It's a property rights system. Property rights have always been used and abused for all kinds of things. And, I mean, as you pointed out, it's not just the little creators, it's also Disney, right? Like on both ends of the copyright spectrum, there's been abuse of the copyright system. All right, so it's not surprising. Second of all, I think to Casey's point, yes, if we're concerned about sort of our epistemic system and truth and attribution, and we're concerned about the demand side, not just the supply side, that's a problem that copyright's not going to solve, and that's a bigger societal problem. So I think we can stipulate copyright has a piece of this, but not all of this. And maybe we can, in the next round, we can get to this. I'm interested in kind of the plumbing, things that we can do that will help on the copyright side, but also help more generally with some of the other problems. So for example, with attribution, there are provenance, systems, and there are ways in which they can be fortified. And there are ways in which that can maybe, without expanding copyright liability, there are ways in which maybe that can address some of the credit, needs for credit that copyright holders want. It doesn't, and it may also advance compensation and control and consent if at least we can determine what the provenance of both the training data is, the inputs, and also the outputs. And I think the same is true, Professor Bracha said that this is not free riding. And maybe we can talk about that a little bit, because I think it is kind of free riding. Yeah. And I certainly think it's free riding on the journalism. And so to the extent that that's what we're concerned about, is copyright the right tool if we don't really have the right copyright doctrine to deal with that? But we do have other ways of having, I think, who said tax and tax and redistribution. Okay, so we have ways to deal with that. All right, I'll shut up. But so copyright is definitely a piece of this.
So I have two directions that I want us to go, and I think we'll go first to the question of what redeeming qualities does the copyright system have specifically? What are the set of problems that we can solve? And then I want to shift us over to the broader range of problems that we have a pretty good sense it can't solve. And Ellen, I'll come to you for the latter question, but let's start with that first one. What is copyright going to be really good at? Amanda?
I love that was just met with silence. Everyone's like,
No, Ellen pointed at you, so you got it.
I think there, even though it is not meant as a privacy enforcement tool, and I think Sarah is very right to be skeptical of that, even though a hilarious amount of my scholarship is about why we should do that anyway. I think that it is actually, given the interests over time that have shaped copyright law, which are very powerful, we do have a really robust hammer to hit some nails. And some of those nails may be related to privacy. We've seen this play out. Casey alluded to non-consensual intimate imagery earlier. The DMCA is a really powerful tool for taking some of that stuff down when simply asking nicely to a platform doesn't actually make any difference. And we saw that with Celebgate in I think 2014, which I know Sarah has also written about. We may see it happen with tools like face surveillance in the context of, say, Clearview AI. There may be entrepreneurial plaintiffs, lawyers who are looking for, in the same way that they've used right of publicity in this sense, which is really not exactly what right of publicity is for, as Jason Schultz has written about, it can be appropriated for some of these privacy-related, justice-oriented solutions. And I think that in the hands of creative, competent lawyers, there may be an opportunity to push copyright law into this space where it doesn't cleanly belong, but Warren and Brandeis looked to copyright law to get some guidance in their Hallmark privacy law review article. I mean, to the extent that we're talking about scholarship not by CU professors, which I honestly don't think we should get into too much. But it's been there all along, and there's not necessarily a reason not to think that it can't do some of this work here. The other thing that I think is so important is one of the factors, or I guess I should say sub-factors of a factor of fair use that some courts look at, including the Supreme Court, is whether a technology serves a public benefit. And one of the things I'm exploring right now is, well, how can you dub something a public benefit without truly grappling with those countervailing public harms? And is there a place in copyright law to force courts, force lawyers to grapple with those public harms and come to a fairer resolution than fair use necessarily requires? That may, as Alan was saying, put some credit, put some compensation, put some consent back where artists and authors and journalists want it, not necessarily where copyright law requires it. And that's something that I'm looking at in some of my current work.
Other thoughts on copyright as a hammer? Mike?
So I already made my argument about why the economics and underpinning really matter. One of the questions I have, well, really two. One is the whole tax and redistribution thing. I want to address that for a second. One of the things that copyright does is it keeps journalism, keeps authorship apart from dependent on government subsidies. And I think that government subsidies are a really dangerous thing when it comes to content. We see, if everybody here watches what happens in politics, and you see attacks on the media all the time. One of the simple ways to attack the media is to threaten the economic foundations. Then people get very cautious about challenging government, and that's one of the fundamental things that we do. And so I think that's a weak system for that reason, and I think charitable sources are weak systems for that as well. And I also think that we shouldn't operate from the assumption that if there's a licensing model that AI can't do everything that AI wants to do. There are dozens, hundreds of collective rights organizations that have built up. Once you have a system of rights, the market's been able to generate solutions to that. There's the Copyright Clearance Center for print. There's dozens of music licensing organizations, from composers represented by CSAC and ASCAP and BMI. There's photography with Shutterstock, and Getty Images is another solution. But there's lots of ways to organize when you have a need, and you set yourself a desire to solve a particular problem of rights. There are ways to license in bulk, and even vast bulk, that can be organized when people have an interest in doing it.
I actually don't think copyright funds journalism. I think that journalism has been funded largely as an accident for the last 100 years. If you look at sort of the decline of the alt weeklies, a lot of that has to do with Craigslist, because it turned out that everyone was picking up and reading the alt weeklies and putting ads in the alt weeklies because they needed to sell their used car, or like sublet an apartment, find a job. All of that economic activity went somewhere else. It was an accident that part of the private sector was bundled with journalism. That has nothing to do with journalism. You could take any random business, bundle it with a newspaper, and suddenly the newspaper is viable. I don't think the New York Times makes its money like its reporters who do an incredible public service. Trying to decide how much to say about my former employer. The thing is that like, good reporting is very expensive and it does not make that money back. You have to make that shortfall up in with other ways. In the case of the New York Times, it is not copyright law, it is trademark law. It is the swag that they sell. It is the fact that there is cachet involved in you having a New York Times subscription. It is the crossword puzzle, because now you're erudite because you have a crossword subscription. It is, and New York Times Cooking. New York Times Cooking makes a lot of money compared to what its footprint is at the Times. And part of that is the fact that it's very hard for people to find recipes online without being blasted in the face with a lot of ChatGPT generated AI garbage that has a lot of ads on it, right? To sort of cycle back. Wirecutter also makes a ton of money because people don't know how to dredge through the garbage, and they trust the New York Times because their trademark is extremely strong. And the fact that their trademark is extremely strong actually doesn't have that much to do with the reporters. Like the reporters, they don't care about their trademark being strong. They're just there to do journalism. Meanwhile, the advertising division is like going to the advertising conferences and saying, hey, give us multi-million-dollar deals because we're the New York Times and this is what we do. And the image that they present of the New York Times being, you know, we're sort of, I mean, the Washington Post can eat out on Watergate for the next 100 years, right? But New York Times has to go with like, we tell the truth. Like they had an advertising campaign that was just the truth, dot. And they were able to sell a lot of ads on that. And it's like, there is this aspect of news making and doing the public a service that is a little bit accidental, a little bit savvy, but it doesn't have to do with the market value and the demand for this public service. And I don't think that copyright law is doing a lot of the work here. I do think that shifts, especially in copyright actually, shifts in the marketplace have resulted in a radical decline in how expensive news can be, and also how many people you can put in a newsroom on how much money. Like I talk to someone who's like a generation ahead of me, and they'll casually throw out, oh, I wrote this essay. This is the backstory of how I wrote this essay. And then I bought a summer home with the royalties from it. And I'm just like, dude, like, I love my job, but I'm not gonna get a summer home out of it, right? Like that's not happening. That's not in my future. Things have changed very, very quickly. And I think a lot of that is accidental. And it's like, it's not like my copyright got suddenly super invalid compared to like my colleague from another generation. There have been just seismic shifts because we chose to align ourselves with specific kinds of business interests to fund this thing that was ultimately a loss-making proposition. And we bet wrong in 1,000 different ways.
Mike, I saw you itching there. Do you want a two-finger rejoinder to any of that before we move on?
Fine, I just didn't mean it that way, but I absolutely think that those brands are built by their content. And I think that every reporter for the New York Times and every editor sits there and says, does this make my brand stronger? Does it make it weaker? Is this who we are as a journalistic organization? And they care really, really deeply about that. You know, I spend a lot of time with journalists. I spend a lot of time with people like Sarah, who cares really, really deeply about her name and her byline being associated with quality journalism. And so I do absolutely think that that's, you know, an important facet of all of this. You know, certainly the markets have changed. You know, the positions have changed, the economics of journalism have changed. But I think that fundamental connection between a user of news and information services and knowing the source. I make one other point, which is that I think Casey's right that there's a lot of misinformation out there. And I think a lot of people are gullible about it. I also think it's remarkable to me how people I talk to who are younger and digital natives have a pretty good source of what to rely on and what not to rely on, or at least what to check on and what not to check on. When my kids go to, Amazon, just to pick on somebody, they quickly point out, that doesn't look like it's real, and that does look like it's real, or that, best of list is not, is paid for by an advertiser. It's not legitimate. And I think there are a whole bunch of signals that they rely on for that. I think it's really important as we think about AI to keep those signals in place so that people have ways to tell what's true and what's not. It's not going to be perfect, and there's going to be plenty of disinformation and people who are, maybe laws, but hopefully laws that make it harder to create deep fakes and to create mis and disinformation and not identify its source. But I also think, just that attribution piece. It's also important from an attribution point of view that people not just take the attribution. So coming back to copyright for a second, there are some experiences that people have designed that show attribution or something that's akin to attribution as a way to create validity for the output of an AI. And those get you the attribution piece, but what they don't do is anything about the economics, right? So in other ways, they're even trading more on those trademarks that are valuable and saying, oh, you can believe in this. It came from the New York Times, but it's not generating any revenue for the New York Times. It's not generating a link like they used to get from search. It's not generating an ad revenue at all. And these are issues that copyright law may not be perfect, but it's going to have to address.
One really quick addition that occurred to me. I really want to go back to tax and redistribution is not, I think, off the table. Because there is a very private public framework for monetizing music. We don't have this moral panic around the fact that the streaming royalties are very much intertwined with Washington. It's so arcane that I really don't want to get into it. Let's just not do it. But there is no moral panic around that. There is no moral panic around the fact that we have a quasi redistribution framework there. And yet for some reason, tax and redistribute has never been considered in a serious way for news, art, etc. Maybe we should put it on the table. It's music isn't perfect, but it hasn't failed.
Well, the obvious answer there is the government has terrific taste in music, not other things. Ellen, I want to shift to our next part of the conversation and come to you. And we previewed a bunch of this already, but let's start talking a little more explicitly about the problems that copyright does not cover, or maybe to frame it a little more positively, the overarching regulatory agenda for AI. Give us a sense of what that landscape looks like. And we've got bits and pieces of it already, but bring it together.
Well, the takeoff point that I'll use is this word trust. And I think, so Michael, you use the word, brands or sources that people trust, and trust has become kind of, I think it was the OECD that first used this trustworthy AI, and I think it would be really interesting to interrogate whether that's a good framing or not. But that is what kind of Europe and the US have come to use as the goal, right? And so trustworthy AI, and it doesn't have a ton to do with copyright, although as I said, it sort of touches on copyright to the extent that we view, sort of credit, attribution. Those are all attributes of trustworthy AI: safe, reliable, privacy respecting, fair. All of these kind of abstract nouns, or those nouns, adjectives are sort of, that's what makes trustworthy AI. Okay, so very few of those, whether or not an AI system, and let's just take it out, let's say just narrow AI, so hiring, an AI system that's used for hiring, whether or not it actually does what it says it can do, which is to sort the wheat from the chaff in terms of the applicants, whether it does that in a way that's better than the human judgment that it replaced, that is a question of efficacy and validity, and that is a question of trustworthy AI. Don't think copyright has anything to say about that. And we could go down the list. So I think each of those in the US structure is kind of dealt with, those attributes are dealt with in verticals, in sector-specific verticals. And we could talk about whether or not, like, the pros and cons of dealing with them that way. The last thing I'll say about copyright is that copyright's a speech regulation, right? It's like one of the only speech regulations that we have. And I think that's another reason for this overweighting of it, because now we've got, AI, or before that, just like ones and zeros, and our digital world is all mediated by speech. And then once we breach the kind of the digital, meat space divide with autonomous agents, our whole world is going to be kind of mediated by speech. And we have in the US all of these, for better and for worse, obstacles, First Amendment obstacles to regulating speech. And so, that in answer to your question, what can copyright do or not do? Copyright is kind of our only speech, one of our few speech regulations. And it's a question about how much we can regulate these other things, including the production of deepfakes, with any other tool.
Although I would observe with copyright that where it giveth on speech, it taketh away, because we have to deal with all those gnarly questions about fair use, which at least Justice Ginsburg claims is a creature of the First Amendment. But I want to keep going on this list and make sure we've got the full list. Any other contributions to the list of problems that we need to be worrying about that we haven't mentioned already? Any other others that folks want to throw in the pile? And then I want to get to this question about verticals and how we do this and in what institutions. But any other policy concerns that we ought to have on the table here? All right, pin drop. We've covered it all. Well, let's talk then about how we go about doing this. And one, I think, sort of question that's come up throughout the conversation today is, where's the institutional home for doing this? So with copyright, we've got the Copyright Office is doing some policy making, some adjudication. Oh, and interesting just to point out that after all the conversation about authorship this morning and AI authorship, that didn't come up in this conversation as a real sort of policy concern at all. Kind of interesting that no one mentioned that. But we've got the copyright.
It's just copyright.
That's just the copyright thing.
They talked about it a lot.
So we've got the Copyright Office, we've got courts, we've got Congress. How do we feel about those institutions for policy making? And then let's turn to the institutions that might be able to deal with some of the other problems that you teed up, Ellen. How do we feel about copyrights institutions?
But you don't think that tech companies should just be regulating themselves? Like,
We always have that option on the table.
In fact, the Google, not to pick out on one company, but Google in their privacy policy of all places has said that they will train their AI on anything that's publicly available, whether it violates terms of use, whether it violates copyright or anything else. So it is kind of an example of the big tech companies just trying to establish the rules.
All right, so we could add self-regulation in the mix.
Yeah.
Let me zero us in though. Let's talk about courts, right? So I think a lot of
Yep.
what we were talking about this morning were hard questions about infringement, about fair use that are ultimately going to be decided, at least in the first instance, by courts. How do we feel about courts handling these big questions about AI? Are they a good venue, a bad venue?
I mean, there's problems with every single venue, right? It's not, I mean, courts, like trust in the courts probably never has been lower. Courts also not great on technology issues necessarily. But on the other hand, one of the sort of weird things that happens when courts meet bizarre technologies and bizarre setups is that sometimes they'll just like put the brakes on things. And like, is that necessarily a bad thing? I don't know. Was it a bad thing that the Supreme Court sort of put the brakes on torrenting? I actually don't know. I'm not sure. I don't think it was good per se, but maybe it wasn't bad. So I'm not sure about the courts. I'm kind of like, Congress, so I think the DMC is a pretty decent law, honestly, like for what it does, like the fact that it was created like well in advance of the Web 2.0 that it came to govern. But on the other hand, the Communications Decency Act, which happened before that, terrible law, awful, just no good whatsoever. And so like, that's kind of a mixed record. And also that was a Congress that was much more functional and probably had less of the brain drain problem that we face. The admin state and the executive branch, it's pretty good under the Obama administration, but there's been kind of a sort of a period in which it's sort of not been quite as good as it was before. It's been kind of gutted. So I don't know, like there are no good solutions here. And then of course, then there are the tech companies and no.
Yeah, so
sorry, go ahead.
I just thought I'd add a little bit to your list. So there was a recent summary judgment decision relating to copyright, actually in the legal industry about the copyrightability of Westlaw notes, if I remember the case right. And the court said, I really have no idea how to apply the fourth fair use factor, the one about the effect of the use. And so I'm just going to kick it to a jury. So you need juries on your list. In the case of situations where Congress hasn't acted, we've seen the States act. In California, there's legislation pending that would provide compensation for journalists from large tech platforms as kind of a competition remedy. So that's been picked up by the state because it's a little stuck in the congressional level. We've seen state AGs get into the act. We've seen international bodies, certainly the EU and other countries get into the body, as well as a variety of international treaty organizations. All of these organizations have a variety of influences and pressures on them. Some of them are very parochial. Very few of them actually are trying to consider the system as a whole, kind of free of those kinds of influences. So I think, I think it's a really, and everybody wants to jump in on the act right now because AI is a hot topic. And so it gets a lot of attention and people are really not that knowledgeable about it. They're not that expert on it. We can't really expect courts who might hear criminal trial one day on some thing having absolutely nothing to do with technology and the next day to become an expert on artificial intelligence and the way it works.
So oh, sorry, Amanda, you go.
I would love to hear from you.
I was just gonna say, when Kathy Lee was talking in the last panel, so much appreciated what she had to say about how we have choices, right? But while she was talking, and she was talking about, ways in which technologists could move in one direction or another, and they need incentives. Okay, so how do you get incentives? You get like big judgments that focus the mind. And so I like the idea, and that we've had this kind of desert because of 230, and we haven't really developed those. So I like that idea, but I think courts are going to need help because if you think about, if they have to decide, I'm talking about outside of the copyright context, if they have to decide, in a products liability case or in a defamation case, because we're going to have defamation cases, well, is there a duty of care? What is reasonable? And, actually, God forbid if it's like an intent-based standard, like AIs whose intent, And so, but on those first two, especially on the reasonableness, this is where I think like researchers and, technical standard setting, like NIST, and sort of this kind of what I think of as the plumbing here, as that develops, that will assist courts in like actually having inputs into what best practices are.
Amanda.
I think before we get to any of these institutions, there's another very important institution that we haven't talked about that is positioned in all of the ones we have, which are lawyers. Hopefully all of these, certainly all the major AI developers and big tech companies have lawyers inside and outside that are advising them on copyright and a whole host of other AI related issues. But I think that's really an opportunity for two reasons. The first is if lawyers are taking a client-centered approach, their goal is to present their clients with all possible consequences of their actions. And to pair that with their ethical obligations and empowerments under Rule 2.1 advisory, they can advise on moral, social, political, and economic issues, not just legal ones. And a lot of the harms we're talking about are straight at that intersection. Socio-technical harms are moral harms, they are social harms, and they are political harms. So if you have a client-centered lawyer advising some of these clients using their full toolbox, they may be able to come forward and say, listen, you asked me to look at fair use, but I'm really seeing a bigger issue, which is, should this technology exist at all? Now, that might not be something that the client wants to pay $500 an hour to hear, but that's something that the partners can write off at the end of the day. That doesn't mean that lawyers get to shirk their ethical obligations to have those difficult conversations with clients. And I think that we've seen, I don't know what those memos look like behind the scenes. I would like to think that there is a number of really competent lawyers at really competent firms or solo practitioner offices giving this kind of really excellent advice to their clients. But I think that this also is a fundamental Rule 1.1 issue competency, which is a lot of lawyers are not really competent to advise on these complex socio-technical issues. And that is a bigger challenge for, I think, all of the different institutions we've talked about, because they are built largely of lawyers. If there's a competency issue, we're actually not having a robust, thoughtful conversation about how to address harms. We are running straight past that and going into the law that we're most familiar with and bypassing a lot of the issues that really deserve attention. So I would add lawyers to the frame. And I would say particularly that client-centered lawyering that really embraces that 2.1 ethical obligation and pairs it with taking competency seriously can be a really powerful tool in shaping better technologies.
Unfortunately, I think the reality is that lawyers are going to be using AI to do their research and finding hallucinated cases. All right, I want to take the prompt on ethics and turn to one last topic before we open it up to Q&A from the audience, and that's ethics, not in the legal ethics sense, but in the broader ethics sense. So Casey, this is the focus of your work, and sort of a question, is law even the right vehicle to broach this array of problems that we've thrown out on the floor today, or should we be thinking about ethics?
Well, I was going to add one more thing to the list, which is like the court of public opinion, which I do actually think can have a legitimate impact here. Like, you can be concerned about fair use and you might get sued, but also with enough people who are willing to very loudly critique a technology, a company might come up and say, our model is ethically sourced. And then suddenly you have like a market differentiator, it's organic, a market differentiator.
I like that. Is it gluten-free?
Because I think that a lot of the concerns that are being framed as copyright, if you ask like the average person on the street, they might actually frame it as an ethical issue. A lot of my work has been around like understandings of fair use or like misunderstandings of fair use. And the average person doesn't know what the 4 factors are or what makes something fair use or not, but they have this intuition that maybe this doesn't seem fair. And fair in an ethical sense. And I've been using the example of fan fiction writers. I'm on the legal committee for the Organization for Transformative Works, which I mentioned because I'm not about to speak for that organization or make assumptions about the prevailing attitude of its members. But a lot of fan fiction writers who exist because of fair use. Like it is the underlying, like this, fan works are fair use is why it exists. A lot of people are very upset that their fan fiction has been used to train these AI models, very upset. And this might seem counterintuitive, but it actually makes sense because the norms of that community around copyright are so deeply entrenched in attribution and credit because it's a gift economy. No one makes any money. And so like the worst things that you could do as a fan fiction writer would be to steal someone else's work without credit or make money from your fan fiction. And so the idea that all of this free labor that was given with love, to other people was used to create this technology that they might not be directly benefiting from. Because I think there's a lot of problems with like, are the benefits of this technology being seen by the people who are being harmed? But also it's being commercialized, they're not being credited. And people might say like, oh, well, I don't know that they would argue that it's not fair use, but it doesn't feel right. And I think a lot of people feel that way. And there's definitely there's a good number of people in the sort of AI ethics world who feel that because this technology was built, off the backs of content without people's consent and without attribution, without a compensation, that it is kind of an inherently unethical technology. I don't know if that's the prevailing opinion, but it's a very legitimate way of thinking about it. And that's not something that is a legal issue. That's not going to be solved with the court decision in Getty Images. Even if a judge says this is fair use, that's not going to change people's opinions about whether it was ethical.
All right, I have so many questions I want to go deeper on. Lightning round reactions on the ethics question, and then the clock is telling me that we must turn to the audience for questions. Any final thoughts on this question about ethics?
Copyright doesn't care about your feelings. That's what I heard in the last panel.
But
Except in Europe.
Except in Europe, in the United States. I just have, I care about ethics as much as the next person, but I really don't like the framing of these trustworthy AI issues in terms of ethics, because ethics doesn't really have bite. And I would rather have something else have bite. I do like the idea, and that was lightning, so I'll stop.
I do believe that ethics matters, though, because I do believe, the copyright wars of 15 years ago, I think, are a really good example, which is you can have really good laws and it could be absolutely clear that something's copyright infringement, and if 100 million people decide that it's not, there's really nothing you can do about it. And so I think it's really important that these laws are framed on a base of what people think is the right thing.
I think these sort of ethical considerations have led to a kind of folk copyright law that is bubbling up, and usually you just go, oh, that's not how it works. In this case, the reason why we didn't go into the AI authorship question is because I think it just sort of demonstrates how much of this is up for grabs. A lot of the questions around generative AI and copyright literally doesn't make sense anymore. And if that's the case, then that means this is up for grabs because a court is going to come in and either make sense of it by pretending like this was the law all along, but actually making up something entirely new, or we get a new statute, or we get some kind of a mega disaster court ruling where they try to make sense of the thing, but actually don't, and we deal with the fallout from that. So. Yeah, I guess what I'm saying is that the folk copyright that's bubbling up is actually relevant now because we're sort of on the precipice of big change being possible at all.
Amanda, final word.
I'm gonna let it go to our beautiful audience.
Beautiful. And speaking of our beautiful
I can't
audience.
see them, but I know they're beautiful in my head.
They are.
They are. I just plug it into Dolly. Beautiful audience. I'm sure they get very accurate in that picture. Make sure to add Boulder. It's a little different. As always, the first question will go to a student, and I'm scanning the room for students. Fantastic. Right back here.
Hello. I think we heard a lot about the inadequacies of the system that we have currently, and politicians and or courts who don't fully understand AI. But I'm not a legal scholar, but I do know that the decisions will be made soon and now, whether it is by Google and or our representatives currently. So what piece of legislation would you like to see enacted, if it could just be one right now, that you think would most benefit us in the future with generative AI? Obviously, we have limited information and we don't know what things will look like, but decisions do need to be made.
I'm so glad you asked, because I wanted to ask about political economy. We only get the political economy to do one thing. What's it going to be? Sarah, can we start with you?
I would release funds to probably the FTC, depends, there would be one of the agencies to establish basically a commission, similar to how the FDA has an inside line on the pharma companies, how the FCC has a close relationship with the telecoms. One, have an agency or sub-agency that is plugged into the AI companies in a way such that they get transparency into what is happening to the data in the pipeline, where the data is coming from, what is happening with the data, and start and empower them to do rulemaking and also sue companies for judgments that are larger than the cap that the FTC currently has.
All right, transparency and monitoring. Ellen, let's go down the line.
This is on legislation?
Yeah.
Okay, so massive more resources in the federal government. I'm not sure FTC is one possibility, but across the federal government, and also, additional subpoena power, additional technical competence, so that there can be regulation.
Casey.
I kind of like the AI Bill of Rights framework. I think it has challenges in part because rights are kind of reactive, because it has to be violated and you can do something about it. But I do like that framing that this is a human rights issue. And so I might like to see some actual legislation come out of those ideas.
There's also, I like all of those. There's legislation pending that we create an expert agency at the federal government level that would not take over all the regulation of AI, which is, I think AI is going to be part of everything, but would provide expertise to the various regulatory agencies when they deal with issues that are framed in an AI context.
Fantastic. Amanda.
Everyone already pitched the big pie in the sky, major stuff, but one small thing that I would welcome is codifying public benefit as a genuine fifth factor of fair use, and saying that as part of that factor, courts really need to grapple with the countervailing public harms. I think all the time about Perfect 10 versus Amazon, which is the case that established that Google image search was lawful fair use. And in that particular case, the copies in question were pirated images of nude women who'd previously had their images behind a paywall. And the court didn't grapple with the privacy invasion and dignity invasion and autonomy invasion there. It didn't grapple with Sophia Noble's incredible work about the biases that are now sort of ingrained in Google image search, particularly around searches for women and people of color. And it certainly didn't deal with what is now an issue, which they could not really have predicted then, that Google is becoming a site of promoting misinformation given all of the generative AI nonsense. And while I don't necessarily think that a public benefit factor would overwhelm factors 1 or 4, which, as we've talked about, the market harm is key, and we didn't really spend a lot of time on transformativeness, but factor 1 has always been very important. I do think that forcing courts to grapple with those real socio-technical harms as well as the legal harms would give some breadcrumbs to other legislators or agencies who are looking to create some laser-focused legislation or laser-focused enforcements to address specific issues rather than having the world be quite so broad and big.
Terrific question. Thanks so much. Let's go to the audience. Come right back about 5 rows from the back here.
Well, thank you very much for the discussion today. There have been legal and economic arguments that AI platform provider model really resembles a natural monopoly, which would seem to kind of complexify the property rights or the licensing aspects of dealing with copyright. If this natural monopoly characteristic is in fact true, does that kind of change your approach to the issues?
Yeah, so we haven't touched too much on the competition policy dimensions here. Thoughts on that front?
Sorry, what resembles a national? Is national or natural?
Natural monopoly.
What is a natural monopoly?
In the sense that
No. What
AI models.
AI is a natural monopoly.
AI platform.
Okay.
All right, just for folks online who didn't hear that, the notion is, could the provision of AI platforms be regarded as a natural monopoly, and what consequences does that have for policy? Mike, you want to take the first stab?
Sure. I think it's a little too early to tell on the question of whether it's a natural monopoly, so I probably wouldn't address the issue at the beginning as that kind of an issue. There are lots and lots of work being done on AI, large language models from all kinds of places, and even though some of them are enormously compute intensive, there are others that seem to be less so, and there's a major movement to develop a public cloud that might be funding research at universities and the like and provide an alternative. I do believe that if they do become a monopoly, it has a lot of consequences for lots of these other things. Markets don't function well. when a party on one side is a monopolist, and we're seeing that play through, for example, in the existing internet now with a number of different competition challenges from the federal government.
Other thoughts on competition, Casey?
Beyond just monopoly, I mean, we haven't talked a lot about like the FTC. I feel like a lot of AI regulation right now would be coming in terms of like unfair trade practices and deceptive practices and that sort of thing, which is going to be the FTC or like states. So we haven't talked a lot about that, but that's kind of the structure that we have right now that would probably be might end up dealing with some of the stuff beyond copyright.
Ellen, any reactions?
I mean, just an observation that, there's open source AI, open source models, and that sort of suggests that they're not a monopoly. And in fact, the voluntary White House voluntary commitments on frontier models, if you followed that and the sort of representation that the companies that might be thought of to be at least an oligopoly, OpenAI, Anthropic, Microsoft, Google, they have they've agreed in part sort of to be licensed as if they were monopolies. And then there's a critique that will surely make them monopolies because only they will be able to comply with these licenses. So I think this question of how concentrated are, the large language model purveyors and sort of how we treat that is really important.
But like if you go back to 1996 and you think about all the number of search engines, Yahoo, names like people in this room don't even remember, like Alta Vista and even AOL. It's like Ask Jeeves. There you go. So it's like, I think it's really hard to predict the way that these markets are going to evolve. We're in the really early stages of having these APIs available, and it's not just the search engine functionality, but it's all the things that got added onto it that began to create these big economic forces.
Sarah,
I have no idea whether it is a natural monopoly. I think that you have some really good points there. The other part being that I would contest natural for reasons what you stated. The monopoly over the data would exist in part because of copyright law, like that we live in a post Viacom v. YouTube, post Hathitrust world. And so there are specific actors that have data and access to data because of how things shook out in court and how we decided to approach fair use. So is it a natural monopoly? I don't know. I don't know if it's natural. I don't know if it's a monopoly. Certainly if it turns out to be, it would makes everything easier because then it's easier to regulate. It's easier to regulate 1 or 2 entities rather than like 20 with a new one coming out of the bushes every 5 seconds. So yeah, I don't know. It's kind of, it is an interesting question.
Amanda, any reactions?
In the interest of making sure we end on time, no, I do not have any reactions.
Terrific. All right, I think that gives us time for one last question, bearing in mind that we're short on time. And I want to go to the person who's right next to the microphone, Alder in the back.
Really convenient. Hi, my name is Morgan English, and I am really happy that I got to participate in this panel, or not participate, but be in the audience for this panel.
You're on this panel now. Welcome.
Personally, I work with the Concept Art Association. They represent concept artists, and they were some of the first people to sue these platforms. So it's really great to hear from like having the artist's perspective represented. I had a question about another way some of these platforms are being regulated, which is through self-censorship, and whether, especially for this type of technology, and maybe Sarah, you could talk about this since you know about the history of a lot of technological advancements, where usually that expands the marketplace, where I think in this instance, it might be a little bit more unprecedented, where we're shrinking the marketplace. And if that's, something that can really be dealt with through technological regulations or through legislative regulations, is this going to get solved, or are we going to really see a minimization of creative artists in the industry?
One of the things that I tell journalists when we start talking about AI is going to come take our jobs is AI already took our jobs. Like it already happened. We weren't calling it AI. In a broad sense, search engines are AI, always have been. Astronaut meme. We started writing headlines for search engines a long, long time ago. Revenue became diverted to a long time ago. Newsrooms began shrinking. We already lost our jobs to AI. It already happened. In the 70s, if you look at old stacks of the New Yorker, you'll see that they're much longer. All of the articles are not well edited, honestly. They're like about 150% as long as they should be. And it's because they had too much ad inventory. They needed the text in order to be able to run all of the ads in the New Yorker. That is not the market anymore. I think that we are all in for a hard time. Anyone who wants to do anything that promotes culture and human flourishing and the progress of the useful arts and sciences is in for a hard time. Like, we've been in a hard time, and the money is going to dry up, and things are simply not going to be diverted to us. And the thing that I'm going to point out is that Silicon, really quickly, because I know we're running out of time. Silicon Valley Web 2.0 came about in the wake of the financial crisis and in the wake of the Microsoft antitrust action. So what you have is you have two market interventions, the intervention being the antitrust action, and also monetary easing by the Federal Reserve. Interest rates were very low for a very long time, and that period coincides with the Silicon Valley boom, the second boom. In essence, we subsidized the tech industry. That is money that could have been going to something else. Instead, we chose to give it to the tech industry, and that is the world we live in today. So I'm just going to leave it there.
All right, looking at the time, I'm going to defer further conversation to the reception because we're a couple of minutes. All right, Mike, you're twisting my arm here. Really quick thought.
Really quick, I have two quotes for you, and I just thought you'd like these. One is from Sam Altman, one's from Brad Smith. Brad Smith's the president of Microsoft. Sam Altman is obviously the CEO of OpenAI and has been running around on AI issues. Brad Smith said in front of Congress, it's critical for authors to retain control of their rights under copyright law and earn a healthy return on their creations, and talking about AI. Sam Altman said, and I'll cut down the longer quote, but he says, we believe it's really going to deliver that. But content owners, likenesses, people totally deserve control over how it is used and to benefit from it. So we have two of the biggest players in AI saying that we're going to work this out.
On that note, we're going to work this out. Before we go, it comes to me to do a little housekeeping. October 17th, we hope you will come join us again for the Startup Variety Show. If you like today's programming, on October 24th, we're going to do the next event in our AI ethics series. And then please save the date for our annual flagship conference, February 4th and 5th. We'll be moving next door for a reception. The earlier admonitions about speaking to students still stand. With that, please join me in thanking all of our speakers today for a wonderful day.